Yes, Mr. Lance.
Good afternoon, my lords. Ground 7,
Yes.
that the judge erred in making the relevant comparison of overall impressions. I'm going to deal with just 2 points, and I would like to first ask you to turn to core bundle, tab 11. This is the judgment in paragraph 80.
Yeah.
I accept, of course, that I have to show that the judge has gone materially wrong in some way. It's not enough simply to invite the lords to have another go. So the first point we say is that the judge did not properly consider the weight to be given to the light, incorporated light feature and the glitter in respect of those designs which did not have it. So if one looks at paragraph 80, you'll see that the judge here lists that the informed user would notice being in common between the RDs and Stute and the Aldi bottle 5 points. There's the identical shape of the 2 bottles, the identical shape of the 2 stoppers. Note, shape only, not colour. Colour is later as a point of difference. A winter scene. In the case of 80 and 84, a snow effect. In the case of 82 and 84, an integrated light. For 81, the judge says, in my judgment, and with the design corpus in mind, each of those similarities would appear significant to the informed user, and cumulatively they would be striking. The judge then lists 6 differences. The winter scene, which of the RDs and Stute is white only, whereas on the Aldi bottles there is a colour. Of course, the colour is different. One is orange, one is purple. The infusionist branding, the fronts to the Aldi bottle, just the overall impression of the Aldi bottle is brighter and busier. A watch strap label, and the Aldi stoppers are darker in shade than those of the RDs and Stute. Having set out those matters compendiously, the judge then says, in my judgment, the Aldi bottles do not produce a different overall impression because of the features they have in common set out above. The differences to which Aldi points are there, but they are differences of relatively minor details which do not affect the lack of difference in the overall impression produced by the Aldi bottles on the one hand and each of the RD suits on the other. So my first point is, if one takes the Aldi Blackberry bottle and compares it to UK 78, the only points of commonality on the judge's analysis are the shape of the bottle, the shape of the stopper, and the winter scene. Because UK 78 has neither glitter nor an integrated light. But of course the Aldi bottle does have those features, which means not only do they need to be ignored as a point of commonality, but they should weigh strongly in the scale on the other sides. So in addition to the 6 points of difference identified at paragraph 82, each of the snow effect and the integrated light, the judge says at 81, is a point of significance. And I say when you have to take those points of significance into account. When you add those 2 really significant points and all the points in 82 against the remaining points, of which there are just 3, bottle shape, of course based on a third-party registered design, a stopper, and the point about there being a generic winter scene. In my submission, the judge has gone materially wrong, because certainly in respect of the Aldi Blackberry bottle and the UK 78, he hasn't done the analysis properly, and he's admitted 2 quite significant points which point against infringement. And this is a consequence of the fact that he deals with it wrapped up all at the same time in paragraph 83 without really saying, in respect of this allegedly infringing item, here are the points of difference, here are the points of similarities. And that's
so the error of principle, you say, is failing to do it registered design by registered design.
Well, the real error we complain about is the fact that as a consequence of this, he doesn't take into account the glitter or the integrated light in respect of one or both, in respect of UK 78, 80 and 82. Now, of course, you might say, does this make any difference because there's UK 84, which has both, to which my answer, of course, is to say, well, UK 84, we have the issue that it's a dark registration. And in my submission, that's another very significant point of difference. But if one looks at how the judge has gone about it, you can see that in respect of 78, he hasn't taken all the relevant factors into consideration. And in my submission, that is a material error which allows the court to have another look.
Yeah.
I'm conscious of the time. My second point is the undue weight, we say, he gave to the similarity of the bottle and the stopper. And again, if you look at the list of points in paragraph 80, there are only 5. And the bottle, of course, was a registered design.
So what?
So, well, one would assume that when you're looking at points of similarity, one would have expected the judge to clarify what weight he was
took
giving
the
to.
bottle into account as being part of the corpus.
He did.
But why is the fact that it's a third-party registered design relevant?
Well, only because it's a third-party registered design. If one gave it too much weight, it would effectively tread on the toes of the third-party owner. If Marks and Spencer could say, well, we've used this design, but almost any, if the bottle was a really significant point in itself, such that almost any use of the identical bottle would infringe M&S's design, you might say, well, that would mean that the Saverglass wouldn't, in effect, wouldn't be able to license it to anyone else. So, but what I'm saying is this is something that the judge didn't say at paragraph 80, the weight that he was giving to the bottle, in light of the fact that there was not only the registered design, but also a prior use by Marks and Spencer of the identical Botanics shape. And I needn't go there, but that's the bottle at S62 that we've seen. And the second point relates to the shape of the two stoppers. If I could ask you to turn to paragraph 70. This is where the judge talks about the design corpus. And in going through, he makes comments about the integrated light and the shape of the bottle and the snow effect. He doesn't anywhere explain how the design corpus relates to the shape of the stopper. And if one looks, simply look, these aren't all the examples in the design corpus, but if one simply looked at the images reproduced in the judgment at paragraph 70 and at 71, so on the next page, one can see, bearing in mind that it's only the shape of the stopper we're interested in, not the colour, that on paragraph 70, you can see on the front row, there are at least two stoppers that look remarkably like stoppers in the registered design. And then if one ignores colour, arguably the fourth one along is very similar, and the last one, the top line, is similar. And if one turns the page 120, and again looks at the stoppers, it's not always clear, of course, because labels tend to obscure things. But certainly the last two bottles on the right-hand side of the top line, again, seem to show a very similar stopper, that is to say, circular stopper with a straight top. And in my submission, the judge does not perform any analysis of the shape of the stoppers in the design corpus. And then, because it's listed as one of only 5 points of commonality, which he says is significant, in my view, the judge ought to have looked at paragraph 82 and ought to have said, explained what weight he was giving to it. It appears at 81 that he's really given this a lot of weight in circumstances where the design corpus doesn't warrant it. I'm mindful of your lordship's injunction before short adjournment. I propose to leave my submissions there unless there's anything else I can help you with.
Thank you very much, Mr. Willis. Ms. Campbell.
My lords, to begin with, I'll make some general comments, rather like my learned friend Mr. Edinburgh, King's Counsel, did, and then go through the ground in a little more detail. The court now has samples of the physical products on the bench, and so far as PepsiCo is concerned, we do respectfully agree with the appellant. It is legitimate for the court to look at products. Care has to be taken, of course, to make sure there are no differences. In our submission, there are no differences, save in one immaterial respect. And the immaterial respect is the watch strap, the red watch strap on the product in front of my Lord Justice Arnold. That doesn't appear in the registration. And that's very much the sort of thing that people might, even in a court of law, when examining it for a few minutes, might not notice that difference. The product clearly has an integrated light feature in the base of the bottle. My Lord Justice Arnold correctly in our submission identified the nature of the disputes. These are 4 designs for the same product, but because there are 4 different designs, they each have to be considered separately. We accept that. Now, some more general points. This was a single-day trial in the Intellectual Property Enterprise Court, covering a number of issues, including relevant sector, informed user, and a number of other matters. These issues did not include validity, which was never challenged on any grounds. It would be mere speculation as to why not. Perhaps it was considered to be a bad point, but the effect of the appellant's submission is that arguments which might have been made in relation to validity are all said to come back in relation to infringement, and here I particularly have in mind the grace period. At any rate, it's now a single day appeal before this court on a subset of these points. The appellants have identified 7 distinct grounds of appeal, but we'd respectfully say there's only really 4 matters which my lords need to consider. Now, my lords already seen the marked up annex to our supplemental skeleton argument. I'll just take my lords to remind them. I've seen it a number of times. Core bundle tab on page 88. And we marked up Aldi's prior art live on trial using colours. Red was one the judge did consider. I'll show that to my lords in a moment. Yellow or orange, I think, in some reproductions are all the prior designs. And the green design is the Aldi. And grounds 1 and 2 only go to the orange ones, and grounds 3 and 4 only seeks to introduce the green one. That's the end point of all this argument. Now, the red item of prior art, to use that term, is one of my client's previous products, which the judge did consider, which didn't prevent my client from winning. And my lords may have seen that. It's core bundle tab 11, just above para 34 of the judgment, on page 108. It's the one on the left, 2019 Snowblow. That didn't prevent my client from winning. That was in for all purposes. My own friend doesn't make any criticism of the judge in this respect. So it must follow, mustn't it, that he must regard all the new bits of prior art as being more significant than this, although they have to be considered on their own merits in any event. Now, the 2020 glitter glow that you see on the right here, that was actually a spring-summer product which was launched in May 2020. Hence, no doubt, the elderflower flavour and the bright summer colours. Now, the other 2 of the yellow marked prior art are indeed shown in sub-bundle 2, page 65. I know my lords have seen this. So I'll just show it briefly. Sub 2, page 65. Those are the 2 in particular. Leonard Friend relied on this.
Finding page numbers hard to see. It's supplemental 2, which tab is it?
Supplemental bundle. Did I say supplemental bundle? Tab
said-
2, page 65.
Oh, tab 2. I'm sorry, I thought it said supplemental bundle. Tab 2, page 65.
We've seen this before.
Yeah.
And the only real point in looking at this is to turn back the previous page to see the summer product I mentioned a moment ago on page 64, if my lords go to that. The date first available from at least 14th of May 2020, and then underneath the picture, Marks and Spencer meet the drink of the summer. So these are the 3 new designs which are said to make all the difference. Now, a learned friend presents, for purpose of grounds 1 and 2, a learned friend presents these grounds as being distinct, with ground 2 being pursued if ground 1 fails. But in our submission, it's really 2 different ways of asking the same question, which is what impact, if any, do the proprietor's own disclosures during the grace period have to do with the scope of protection? And of course, the judge reached the same conclusion in relation to grounds 1 and 2 in each of paras 64 and 66 of his judgment. And it's not surprising that the judge, we would say, is consistent so far as grounds 1 and 2 are concerned. Because in general terms, if the court accepts the policy reason for disregarding the proprietor's own designs following the grace period, as identified in sphere time, and I'll take my lords to that, we say it's illogical and inconsistent to consider why you would ignore some of them and not others. We therefore say it's a binary question. We either ignore all proprietors' own design, which affect the scope of protection, or none of them for purposes of considering infringement. Now, there's no hesitation on our side of Lord Justice Lewison detected about the judge's third option, but that was the one that we won on below. We thought it was more interesting to focus on Malone Friend's second possibility, the middle one, because we see that as leading to the same conclusion as the third. And if it does lead to the same conclusion, the answer to the ground 2 is the same as the answer to ground 1. It's the same point. And that second possibility, and I'll go into it in detail, that's Malone Friend's alternative case. And this is a proposition you can legitimately ignore not only designs which are the same or immaterially different from the design itself, but also designs which create the same overall impression of the informed user. And we say if Malone Friend is forced to that alternative position, you're ignoring all the very designs which, on their case, are said to cut down the scope of the monopoly. Now, that's the so therefore we say if the second possibility is correct, Malone Friend loses anyway, and it's a Pyrrhic victory. That's points I'm going to develop about grounds 1 and 2, but by way of highlight, an overview for grounds 3 and 4, it's just considering whether a particular design of the defendant has to be taken into account. And the Lords still have sub-bundle tab 2 open. The defendant's product, to which these two grounds relate, is shown on page 69. And this is another summer product. The article date, as it says at the top, 7th of April 2021. Then there's a picture of it. Bright, colourful design. Priced at very small types, and the price is just £12.99. Aldi launched a peach and elderflower gin liqueur that contains, I think it says 23 karat gold. Main headline, cheaper than the M&S version. And then, again, small type, ready to impress your guests with this spring. So the only point of grounds 3 and 4 is whether this product comes in as well to make a difference. Now, grounds 3 and 4 are, of course, logically distinct because ground 3 is an allegation of procedural unfairness, whereas ground 4 is an allegation the judge was wrong in law anyway, but in practice they largely overlap. I will submit the judge was right in law. In any event, there is no procedural unfairness. As my Lord Justice Lewison said, they've had their chance now, and all they did was not to criticise the judge's reasoning in any shape or form, but just make some points about what they see as the illogicality of the conclusion. And I don't think my Lords were actually taken to the design on page 69, at least not in any detail. And then ground 5, as Malone Friend says, is reassessments with whatever prior art comes in as a result of grounds 1 to 4. There's not very much to say about that. I'll say a little bit about it. And then, of course, the fourth and final area of the appeal is grounds 6 and 7, arguing the infringement case all over again without the benefits of any additional prior art. We say very simply this is just seeking to argue the facts and the judge's findings of fact in a way which is not open to the appellant in this court. We say the judge was right anyway, but it's a pure attempt to re-argue facts. And unless they can say they're perverse findings or rationally insupportable or something of that nature, that appeal, we say, goes nowhere. And finally, there's our respondent's notice. Now, if the appeal is dismissed, then clearly the court doesn't need to consider our respondent's notice at all. Now, in our respondent's notice, we originally had 2 points, which is the integrated light point and the description point. Now, the integrated light points is relatively straightforward. It goes to the 78 and 80 designs, which the judge held didn't show the integrated light feature. Now, as I just said to my lords, it is our case that Malone Friend's attack on the judge's interpretation of the 82 and 84 designs is an appeal against finding a fact which should not succeed, and my junior Dr. Selmy will address the court on that. Now, upon that same logic, we would accept that our respondent's notice in this respect could legitimately be the subject of the same criticism that we're seeking to overturn a finding of fact. But if Mullane Friend's attack against the judge's interpretation of 82 and 84 gets off the ground, then we say by parity of reasoning, we should be entitled to challenge the judge's interpretation of 78 and 80. So that part of our respondent's notice is in the nature of a squeeze, which only arises if and to the extent that Mullane Friend's appeal on the construction of 82 and 84 gets off the ground. Now, the description point is more complicated. And this arose, what Lord Justice Arnold has noted, because at the time of the trial, the register used the phrase light up the gin bottle as a description. The judge noted that in paragraph 15. And we've already looked at the registrations as they were at trial, Supplemental tab 1, page 2, we don't need to look at them. They use the term description at that point. And the point about that, as we say in our respondent's notice, I don't think you need to turn it up, but if Mullane Friend wants to look at it, it's Core Bundle 7, page 57. An application must contain a product indication and may contain a description. But in either event, neither the description nor the indication shall affect the scope of protection. That's written into the directive. However, what's unusual in my Lord Justice Arnold's experience, and certainly in mine, is the register has changed since the date of the trial. We haven't actually got the printouts of the. We can hand them up if necessary, but it's factually correct that the word light up the gin product now appear as the indication of the product, not as the description. Now it follows therefore that our original argument no longer runs because the text relied on is no longer the description. It's the indication instead. And it's still the position that the indication doesn't affect the scope of protection. However, we respectfully adopt Lord Justice Arnold's suggestion that the indication can be an admissible aid to interpretation of the images. And in this case, it would be admissible to interpret all four of the images, including those which the judge held and rightly held contained a light, namely 82 and 84, and those which he held did not, namely 78 and 80, in accordance with that indication. Now, we won the case without needing to rely on the indication, so it can only strengthen our case if it's legitimate to rely on it. But the fact remains, that's the indication today. It wasn't the time of trial. And Mullane Friend has pointed out the priority documents. They didn't mention it either. So there's a possibility that we perform the assessment today, and that's not inconsistent, of course, with the assessment of overall impression in particular being at the priority date. But if the correct approach to interpret the registration is as of today, then it does have an indication as of today. And that does say light up bottle. And that's really all that can be said about that particular point. Now, I'll say one other point. We do respectfully invite this court to decide the case rather than remitting it. Mullane Friend's skeleton did contain a suggestion that the court might consider remitting it. And the basis of that suggestion was depriving the parties of effectively the only level of appeal. We reject that for the following reasons. Principally cost. These are products which relate to a time period some time ago. And we'd like this court to give finality to this dispute. But I don't accept Mullane Friend's argument that determining matters in this court would deprive the parties of effectively the only level of appeal, because this court will determine the relevant principles of law. And if there were a second trial at first instance, that judge would apply those principles of law and find the relevant facts. And we would say there's very little prospect of an appeal against that, because the law would be determined by this court, and the facts would be finding the facts. Now, against that background, my lord, can I address my lords on Mullane Friend's analogy with priority? And in short, we submit this is of no assistance, even in principle. It's of no assistance because priority is a different legal concept to the grace period. It's not related, as Mullane Friend said in the written submissions, save at a very general level. so general as to be useless. Now, the priority period provisions, the Lords were taken to them, sections 1B7 and 14.2 of the 1949 Act, extensively amended. I'm not going to do that again, my Lord. And that's because I agree with my learner friend's analysis of those provisions. 14.1 provides that if an applicant has already applied to accept from the convention country, has up to 6 months to make an application of the same design in the UK. And section 14.2 provides that if the applicant does so, it's treated for purpose of novelty and individual character as if it had been made on the original date. I agree with my learned friend. The purpose of that can be traced back some considerable time, as he says, and it means the UK application will be treated as if it were made, or had been made, on the date of the convention country application. Of course, that means that all intervening prior art between the date of the first application, which is the priority date, and the actual application date are ignored for purposes of validity. That's what priority means. And it's true this period might not be 6 months exactly, but the time period doesn't matter to the principal. The purpose of priority would be exactly the same if it was 3 months, 12, or anything else. But the point about priority is the relevant date for determining novelty and individual character has changed. It's no longer the date on which the application was made in this country. It's the date on which it was made within 6 months in the convention country. Now, the grace period is different in principle and has different provisions. And my lords have looked at that. It's all in 1B, subsection 6 and 7. Let's just look at it so we have it in front of us. It's authority, tab 18. Section 1B. And my learned friend went through all this, which, as he says, relates to validity. Is dealing with novelty and individual character on 1 and 2. And then 5B and 6 sets out various sections. Now, the important point about subsection 6, or rather the first important point about subsection 6, is it doesn't alter the date at which novelty and individual character is being considered. Instead, it's setting out various statutory exceptions to the disclosures that can properly be considered. And there's policy reasons for all of these, but the one we're particularly concerned with here is 6C. 6D over the page is related to 6C, but we don't need to worry about that. Now, looking at 6C, rather 1B subsection 6, subsection C, on its face, it applies to any disclosure made by the designer or any successor in title, and doesn't pose restrictions on the nature, quality, or quantity of such disclosures. The only question is whether it is a disclosure made by the designer, or indeed any successor in title of his. Now, just pausing there, that wording doesn't suggest there should be any narrow interpretation of this exclusion. And secondly, if we do now look at the words or any successor in title, or indeed if we look at 6D and C, made by a person other than designer or any successor in title of his during a period of 12 months, in consequence of information provided or other action taken by the designer or successor in title of his, we can legitimately infer, I would submit, the legislature intended to provide comprehensive protection to disclosures which in one way or another actually originated from the designer. Again, this doesn't suggest a narrow interpretation of the exclusion. And if we just focus on the designer's successor in title, that person may have had nothing at all to do with any of the designer's disclosures. And that's likely to be true in many cases where registration is assigned at all to a successor in title. And yet that successor in title can also benefit from the statutory exclusions in the sense that none of his predecessors, i.e. the designer's disclosures, can be taken into account when considering novelty or individual character of the newly acquired design. And now I would say, is there anything anywhere else in the statute to say that the designer's rights for purpose of infringement, for instance, should in some way be cut down as a result of disclosures made by the designer during the grace period? Because if there is something else in the statute which might give that impression, where is it? And finally, of course, as I said, this has nothing to do with making previous applications in convention countries. Now, what was the purpose of the grace period? There's no real dispute as to that. It's set out in sphere time, and authority which cites the clause, and the judge accepts the principle.
Well, it's
I'm
in the
afraid it
regulations, isn't it? It's in the recital of the regulation.
Recital 20 as well.
Yeah.
Yes. I do want to have a little look at sphere time anyway, relevant paragraph, but I'll not try not to dwell or linger on it. Sphere time is a joint authorities tab 6. And just to orient ourselves, if we go to, first of all, it's a decision of the General Court, appeal from Boyd. So it's just about validity, because we don't consider that. And the question here is set out in paragraph 22 of the judgment, page 141 of the bundle. Is the question of prior disclosure of something called the Symbicort design. And my lords have already had paragraphs 24 and 25 read out to them, so I'll read that out again. But the policy is all about determining that the design concerned is a commercial success, performing the costs relating to registration without fear the disclosure that takes place at that time may be successfully raised during any invalidity proceedings brought after the possible registration of design concerned. Now, the Lords have seen this. Can I make the following submissions about it? First of all, there's no doubt that this is the policy. Ascertain whether it's commercial success. That is the policy of Article 72 of Regulation 6, 2002, in other words, grace period. Secondly, I would say the fact this is the policy of the grace period surely comes as no surprise, and it's difficult to think of any other logical policy of the grace period. Now, secondly, it does refer to invalidity proceedings, second last line of 25. And that was because the proceedings before the General Court were invalidity proceedings. So far as the policy of allowing the creator to ascertain that the design concerned is a commercial success before incurring the costs relating to registration is concerned, we submit there is no obvious reason at all why that policy should be restricted to invalidity proceedings. In fact, if a learned friend is right, the grace period represents a trap, because steps taken by the creator could, if a learned friend is right, somehow cut down the scope of his own rights in the subsequently granted registration. The more he does to exercise his rights to see if it's a commercial success, the more he makes his own subsequent design valueless. The learned friend gave no reason of logic as to suppose that the policy should be so restricted, other than the circular when he says, well, this is the purpose, and it's your lookout if you do take advantage of the right to make various tests as envisaged in this way, and if this means reducing the scope of your protection, then it's your fault. But my submission, that's just the circular argument. It assumes what it requires to prove, and it doesn't deal with the logic or policy of this section. And finally, on sphere time, it's true they're not considering here the precise nature of what the creator can do in order to ascertain the design concerned is a commercial success. But again, that was because they only had to consider a single one, which was the Symbicort in this passage. But they are at least firm, I would suggest, that whatever is done can be done without fear that the disclosure that takes place at that time may be successfully raised during any invalidity proceedings brought after the possible registration of the design concerned. So that's the policy of the grace period and various submissions about implications thereof. Standing back and returning to my own friend's attempt to draw a parallel between priority and grace period, I've already identified a number of differences. I would stress 5 as follows. The first one I've already said is priority relates to applications in convention countries. Grace period relates to disclosures by designers or their successors in title. Secondly, they relate to different people because they have different policy aims. One being to enable applicants to claim priority from overseas applications, and the other being to protect designers against the consequences of their own disclosures. Thirdly, priority moves the date upon which novelty and inventive character is assessed.
Sorry, say that again.
Sorry. Secondly, different policy aims.
Yeah, got that bit.
Yeah. I was on to thirdly.
Yeah, indeed.
Thirdly, priority moves the date upon which novelty and inventive character is assessed, pursuant to section 14.2. Grace period keeps the same date, but excludes various disclosures of consideration. Fourthly, one applies for up to 6 months, and the duration up to 6 months, and the other is a fixed period of 12 months. So 4 reasons as to why these are really very different things, and the attempt to draw an analogy, we say, goes nowhere. To which I would add a 5th point: you could, of course, have a combination of a grace period and a claim to priority, because they're not inconsistent. That was true in this case too, as the judge held at paragraph 59. Now, thus far, I've not addressed my own friend's submissions on how the grace period affects infringement in this case, just as an analogy between priority and grace period. But as we understand his argument, my own friend's argument in this respect does have a number of steps. I'll say what the 3 steps are in Malone and Friend's argument, at least in his written submissions. First step, Malone and Friend's argument is to say the legal test for determining overall impression can produce different results when considering validity and infringement because of what he calls a different context. And Malone and Mr. Edinburgh confirmed that orally in answer to questions from Lord Justice Arnold. He says a legal test can produce different results, even though the test is the same, because he says the context is different. And we say that's wrong. The second step, at least in the written argument, was to draw an analogy with disclosure by a third party. That wasn't something we heard much about this morning, so I'll deal with it briefly. And thirdly, Malone and Friend considers disclosure by the designer, which we heard rather more. Now, the judge dealt with these in paragraphs 60 to 64 of his judgment, which are respectfully amended to the court. And so far as the first step of Malone and Friend's argument is concerned, I would take the court to paragraph 61 of the judgment. This is about the legal test. And paragraph 61 of the judgment is on page 117. And we respectfully submit it's not assumption, this is actually correct. And that's an end to the point. Now, Malone Friend accepts, as I say, that the test differs. The test is the same, but applies different results, he says. Now, I did have some submissions about the actual tests being the same for validity and infringement. I don't think I need to go to these submissions, because Malone Friend accepts that the test itself is actually the same. There were just 2 cases, well, actually 3 cases I would like to go to in any event to make the next point. And one is my Lord Justice Lewis in the first instance in the Procter & Gamble case, at paragraph 26 thereof. And that's in the Joint Authorities tab 2, page 43 of the bundle. And here, Mr. Justice Lewis, as my Lord then was, says it's common ground that validity and infringement obviously reverse the same coin. the test that applies to determine whether there's been a valid registration is the same test that applies in order to determine whether there has been an infringement. And my learned friend says correctly it wasn't disputed in that case, but we say it's still correct anyway. Now, the Court of Appeal decision in that case suggests that there might be a difference between validity and infringement due to the difference between recitals 40 and Article 6 of the design regulation.
This is a clear difference. or
Clear-
not
clearly
quite,
different,
isn't it?
yes.
Well, I think Lord Justice Jacob had second thoughts about that.
Correct. And that's Dyson and Vax, Joint Authorities, tab 5, page 130. So there is no difference. Right. The authority which my lords might not have seen is one called Pulse On, which I think involves my lord, well, two of my lords. It's Joint Authorities, tab 11. I think it's correctly pronounced Pulse On rather than Pulseon. But it was a decision of this court. My Lord Justice Moylan were part of that court. The third member was Lord Justice Floyd. And all I really want out of this is one paragraph of general principle, and that paragraph is paragraph 15 on page 301.
Yeah.
And I'll just read it out. The provisions relating to validity dovetail with those relating to the scope of protection, thus infringement. The scope of protection includes all designs which create the same oral impression as the registered design, or as the regulation prefers to put it in Article 10, designs which do not produce an overall impression. Thus, the overall impression created by the registered design is used to determine both infringement and validity. And here's the important part. As with other areas of intellectual property law, such as patents, it is important to apply a consistent approach when determining infringement and validity. While the two issues are distinct, the overall impression created by the design deployed in determining each issue must be the same. We say that is the point of principle here. Now, they don't deal with my learned friend's argument that you might apply it in a different context. But what is my learned friend's reason of principle for saying that applying the same test, the overall impression test, in relation to the same design should possibly produce different results, depending on whether you're considering validity or infringement?
Well, I think Mr. Edinburgh would say, well, that may be what the law should be, but it's not what it is.
Yes.
Because when you look at the detailed way in which section 1B 14 are drafted, they are expressly restricted to the questions of newness, novelty, and individual character, and they say nothing at all about overall impression. I mean, that's the argument you've got to meet. It's a
Absolutely.
very close textual analysis
Yes.
of the words of the legislation.
Yes. No reason of principle, just a close texture analysis
Yeah.
of the relevant legislation. I understand that. And so perhaps, yes, I mean, coming back and saying it's silly if that is the law, but I still have to address the point.
Absolutely.
And my learned friend is right to this extent, that the grace period, it just isn't mentioned in the context of the infringement provision. That's absolutely right. Then that brings us to the whole question of the appeal. Should the law adopt a different approach? And my submission, no, it shouldn't, for all the reasons given by the judge, which I'd submit are good reasons. And why, on the facts of this case, would you apply the test in such a way that it had no impact at all on validity, which it can't do because validity is not challenged, but did, however, cut down the scope of the rights when considering infringement? My friend says, he only has the textual argument. There's no logic to his argument. And it's true that the previous decisions I've cited, including Pulse On, they didn't consider the particular point raised by my learned friends. So here comes my submission. My submission is if any of the judges in any of the cases, my Lord Justice Lewis in the Procter & Gamble case or the panel of this court in Pulse On, have been asked to consider the proposition the same test might be applied in the context of validity infringement so as to produce different results in the context of validity infringement. My submission is they would have rejected it on the grounds it's not applying the consistent approach identified by Lord Justice Floyd, with whom Lord Justice Lewis and Lord Justice Moore agreed in Pulse On. That has to be a submission because it wasn't a live issue in that case. Now, so far as my learned friend did have an argument that he didn't really pursue orally about, let's suppose a third party which entered the market with an independent recreated product. And we say, well, if it enters, the third party enters the product with a product which is prior art, that's a normal operation of law. It either has a different overall impression or the same overall impression. But there's no unfairness to third parties involved. You know. The only thing I should show, my lords, and it's quite a small point, but it goes to a question the Lord Justice Lewison asked. There is actually a saving provision in here. I think Mr. Edinburgh did mention it briefly. And that's section 7B of the Act in Joint Authorities, tab 18, page 559. There is a right of prior use as set out here.
Yes.
There is a saving provision. I'm not going to say any more about that, other than this right does exist. I don't accept that it's a narrow one, as Malone said. And another point, if I could shoot it down, Malone friend made a point about costs of making application. He didn't rely on that orally. We say costs of making applications have nothing to do with the point of principle. Yeah. So now come to the question of disclosures by the designer. And my submission is nothing less than this, that the statute has decreed that disclosures by the designer trump the interests of third parties. Now that's certainly what they decided for purpose of validity, because we've read that.
Can you explain what you mean by that?
But it's because they're disregarded.
But why does that mean that they trump the interests of third parties?
Well, you might have some third parties, this was part of Malone Friend's argument, come along with a different design. And let's suppose it's a third party who infringes the subsequently registered design. The fact that the design might be invalidated by the designer's own disclosures during the grace period doesn't help the third party infringer, because they're all disregarded for purpose of invalidity.
Yes, I see.
If you're right.
If I'm right, yes. Well, that's I think that's a running.
Well, they are disregarded for the purposes of validity. That's not in dispute. The question is, are they also disregarded for the purposes of
Yes,
infringement?
that's the point I'm developing for the same reason of logic. But the different, I mean, the grace period, Malone Friend sometimes describes it as an indulgence of some sort. It's not an indulgence at all, in my submission. It's a policy choice for the reasons set out in Sphere Time. And if it's not an indulgence for validity, it's not a double indulgence or any indulgence at all to treat such disclosures in the same way when considering infringement, as the judge did. We say it's entirely consistent with the policy the designer's own disclosures shouldn't cut down the protection given to the registered design. The designer's own disclosure during the grace period, I should say, shouldn't cut down the protection given to the registered design. And I'm starting to repeat myself, and I'll try not to do this too often, but if that were the policy, that the designer's own disclosure could cut down the protection, you are undermining the policy, is my submission. I think I made that point earlier. But that is the point. I think what Malone and Friend argument eventually boils down to saying is that if the designer does what the statute allows the designer to do during the grace period, it should restrict, limit, and in ultimate cases destroy the value of the registration he's actually got.
When you, I think the way Mr. Edinburgh puts it is that when you are asking yourself for the purposes of infringement, does the impugned design create a different overall impression as compared with to the registered design having regard to the design corpus? The design corpus that you look at is that which existed at the date of the application,
Yes.
the application in this country.
Yes.
You say, is this right, that if you are required to disregard a particular design for the purpose of evaluating the design corpus for validity purposes, the design corpus as at the date of application must exclude those designs. Therefore, the design corpus, in other words, It is altering the design corpus in relation to this particular registered design.
Yes, that's right.
And once you have changed the design corpus for this particular registered design, that is the relevant design corpus for considering
Yes.
later on whether something has or hasn't infringed.
That's right, my lord. And were the answer anything else, you'd have two different design corpuses.
Yeah.
Can I ask a question that relates to that? Am I right in thinking that nowhere in the legislation, when I say the legislation, I mean either the 1948 Act or the directive or the regulation, do we find anything that explicitly defines what is in or without the design corpus for the purposes of infringement?
Yes, the answer to that is yes, because there's very little anywhere about design corpus full stop.
Yeah.
It's, I think it's recital, it was recital 13, then became recital 14. And that's the only reference. So the operative articles don't use the phrase design corpus.
I think it was developed by the European courts, wasn't it?
I'm sorry,
It was developed by the European court, wasn't it? This idea of design.
well, I'm going to say yes.
Well, it doesn't matter.
Yes. Well, it was a bit, I think my lord's decision on Procter & Gamble and Reckitt-Benckiser was actually one of the first decisions anywhere, I think, on this. And that was the bit about clearly differs and differs, and I think that might be the first decision. So I'm pushing back to say that it might not have been the European court, it might have been my lord. But
Well, since I got reversed, it's a bit of a shaky foundation, isn't it?
yes, but my lord was reversed on the clearly differs point, and the Court of Appeal reversed itself on that. So my lord was right in the end. But my lord's entirely got my point on ground one. And that's really the point, isn't it? Because my learned friend's argument assumes there's two different design corpuses, and that's legitimate. So I think that is the key point. Now that was all I've got to say about ground one. I was going to move on to ground two now. And I already submitted that ground two is really another way of asking the same question. But it's different in this respect, that the judge identifies what he calls three possibilities. And I'm sure that's what I'm referring to. It's paragraph 66 of the judgment in para 118. And to interpret this, we're going to need to look at the Apple RCD case, Mr. Thorne's book. But before we do that, my learned friend's primary argument is for the first of the three possibilities that are referred to here. And if we look halfway down para 66, the first possibility was in such a case, the party would be, would be obliged to register every iteration, including all the failures, in order to be protected. In other words, the grace period, if it applies at all, only appears to the same or immaterially different designs. And that's actually I think my learned friend talked about nil, one, few, many, and this is the one in my learned friend's hierarchy. Now, if that's right, and before that's the case, that would of course be highly inconvenient for any designer, and also for the designer's customers, because the whole point of finding out the most successful iteration via test marketing is that it involves trial and error. So in many cases, a number of registrations would actually be necessary if this were correct. And clearly that will involve cost, because the designers will have to finance hundreds of design registrations, however much or how little they are. They would have to apply for registration for everything. That would add to the designer's costs, and hence the cost to the public of buying the designer's goods, although the infringer's costs are unaffected, because all the infringer has to worry about is the end result. The infringer will typically want to copy the most commercially successful. Now, I've used the word copy. I shouldn't use the word copy because I'm not required to use copying. Registered design is a monopoly. It doesn't depend on copying. But the reality is, in many cases, there is copying of the commercially successful design, which is protected by registration. It's merely not necessary to prove copying. The only question is, does it infringe the registration? But what the infringer would do, the principle's unchanged. He waits to see which is most successful, and he goes for that one. So the infringer gets, he doesn't have to suffer the same problem as the designer of making hundreds of different registrations. And Malone and Friend did, again in writing, pose the question where the designer releases hundreds of designs in the market and then only files for one of them. To which we say that's exactly what the designer is permitted to do. There is no numerical limit to the number of disclosures a designer can make pursuant to section 1B7 of the Act, because they're all disregarded. And there's also a delay point. Now, Malone Friend said that there's always this delay between applying for and getting your registration. And that's because there are examinations for formalities. Presumably the designer would have to delay marketing any particular variant until that variant was registered, if Malone and Friend is right. So if it takes a couple of weeks to get the registration through, they can't actually market it until the registration's in place. And these practical burdens would apply to all designers, whether employed by large companies or small, or the self-employed, small firms as well. I don't know if Laura's noticed that the grace period, as Mr. Stone said, is particularly helpful for small companies. In fact. And the end result of Malone Friend's approach of it only excludes the same design is the register would be filled with a large number of design registrations, many and perhaps most of which would be commercially unsuccessful, of no practical interest to anyone, but they would still confer monopoly protection and use the public from using the subject matter thereof if they thought it was something commercially successful. So there's a lot of practical difficulties with that. And that brings us to the second and third possibilities. Now, I'm going to go to the OHIM decision, the Apple Samsung one, which we looked at this morning. Now, Malone Friend did have a point about this, about there's been some typographical error. But I rely on the point of principle which was established. We go to Joint Authority tab 7. We do have the registered design the case was about. That's page 154. So that was the RCD. We don't actually have a representation of D1. That's the first corky dot under 4 at the top of page 155. It just says containing images and iPhone with a graphical user interface. But we just don't know what it'll look like. And then I think Malone Friend's right about D15 and D16. They really meant to talk about D16, which is at the bottom, on, well, the lower on page 161 of the bundle. Wireless PDA functions with iPhone interface. Again, we're not sure what that one actually looks like. And third is D24, at the top of page 165. When I say top, it's actually second from top. The previous two articles from January 07, this is June 07, and this is obviously another image of an iPhone. You can see that from 3 lines down. So we don't know what any of them look like. Now, Malone and Friend was inviting the court to, I think, to infer that the differences were immaterial. All 3 were immaterial from the registered design. I don't see how the court can do that. The court can't do that independently because we don't have them, and that wasn't the finding by the Invalidity Division itself either. Now, moving to para 44, and I've read this and actually spent a little bit of time on it. I'm not going to read all that. We don't really need to worry about D16 and D24 anyway, because they're referred to in para 45. The real point of interest is para 41. 44, sorry. And here a number of things are clear, I would say, from this paragraph. The first point which is clear is that D1 can't have been the same design as the registered community design. Well, Lord Justice Arnold picked up, because the applicants, who are Samsung, pointed out in the disclosed interface, and they're just talking about D1 here, one icon is missing and some others are in a different order. from those in the graphical interface. And that's not said to be wrong. And it looks like a similar argument was run for the other two designs. And my lords, go back to paragraph 10. The applicants, that's Samsung, seem to be making the same argument for D1 referred to as D60 and D24 about as much designs for which protection is sought. So on the face of it, it looks like all three of them are not actually the same design anyway. And then the holder claim the exception applies not only to the registered design, but also to the designs disclosed by the designer, successor in title, or a third person, upon the information or action of the designer's successor in title, in relation to designs which can constitute an obstacle to the novelty or individual character of the RCD. So there weren't three categories. Actually, there was only two being considered. And the two categories, I would suggest, are designs which can constitute an obstacle to novelty or individual character, and those which can't, because that was the argument being considered by the holder. They don't split it into the same three as the judge. They seem to just think, well, it's either there's the same design point, but also the test is really where it can constitute an obstacle to the novelty or individual character. And we say that's apt to cover both the second and the third of the judge's possibilities. And we say that's for the very good reason.
Sorry, why would that cover the judge's third category, which is any design?
Because it leads to the same conclusion. I agree with what my lord's saying, that any design carries
Unless it creates the same overall impression. Well, unless it is the same design with no material with immaterial changes, it can't be an obstacle to novelty. And unless it creates the same overall impression,
yes,
it can't be an obstacle to individual character.
yes. I
So
follow all
any
that.
design which falls outside those two categories cannot be an obstacle. I mean, you say, I think, in your skeleton argument, well, in that case, it's irrelevant. There's a considerable amount of force in that, but I don't see how the judge's third category
It doesn't go
readily
entirely-
justifiable, if I may say so.
I follow that entirely. It doesn't go as far as all designs. But if we think about it practically, suppose it was something completely different, like a teaspoon or a coffee pot or something. Nobody would worry about that at all.
Well, he wouldn't, because it's nothing to do. It creates a completely different impression.
Yes. I understand what Will's putting to me, and certainly the judge's third category of any product goes wider than the language here. That's certainly true. But if it assumes there's a first, second, and third category, in my submission, no, it's not. The second and third category identified by the judge actually lead to the same conclusion, because they are designs which can constitute an obstacle to the novelty or individual character. And you don't have to decide, does it actually have the overall same impression as well? You just say, I'm not going to consider it for purpose of considering novelty or individual character. That's the distinction, I think. And then my lord's already asked my learned friend about the it and how much weight can be put on the it. Well, clearly the office says in terms they agree with the holder. So they can't really be using the word it to mean the proposition that anything other than what they've just accepted. Otherwise, it'd be inconsistent with a matter of sentences. So that can only be a bit of loose language in my submission. What they should have said is the purpose of provisions to allow the holder of the design to disclose, square brackets, designs which can constitute an obstacle to the novelty or individual character of the RCD, square brackets, for a 12-month period. And that's reinforced because they talk about designers to comply with the conditions of novelty and individual character.
Yeah.
Now, what does Mr. Stone say about this in his book? Now, it's tab 21 in the authorities. We've read on this already. And Mr. Stone in 10.111, he does mention the purpose of reading of Article 7.2, which would therefore allow the protection of grace period not only for crimes but also designs that create the same impression. That's Milena Friend's second argument. And then he does say the office has adopted this approach. Then he reads out the very paragraph I've read.
Yeah.
And then says, in short, the position seems to be that any prior disclosure. Now, there's a number of possibilities here. One is that Mr. Stone actually doesn't see any difference between the second and third either. Second and third possibility, because he says the office has adopted this approach and designs that create the same overall impression in the informed user. And then 10.113, in short, the position appears to be that any prior disclosure by the holder. It's either inconsistent or he regards these as talking about the same thing. And in my submission, the view that they're talking about the same thing isn't that unreasonable when you read the Apple RCD and you see what they were talking about. And it's the words about designs which can constitute an obstacle for novelty or industry. I mean, certainly if you're disregarding designs which produce the same overall impression, then you're disregarding the most important designs. They're the ones which do create or might constitute an obstacle for novelty or individual character. So this, if Milena Friend's on his alternative point, he has to sort of walk a tightrope then, doesn't he? He has to say the additional prior art designs he wants to bring in are not excluded from consideration, but somehow they are just similar enough that they cut down the designer's rights. But if Milena Friend's on a secondary case, if they produce a different overall impression and are therefore excluded from being able to benefit from the grace period, why would they come back in to have a limiting effect in principle? And even if that were true in principle, how do the three yellow designs in this case actually have that effect? Milena Friend didn't explain how the three designs have that effect here. Now that's Mr. Stone's book. The only other one to look at is Russell Clark and Howe, but we've looked at this already. Just two short points on this. It's Joint Authorities, tab 22, page 583, 2141. Milena Friend stressed the word special exception in 241. This is talking about the grace period for purpose of validity. The fact that the authors of the textbook call it a special exception doesn't mean it really is a special exception. I've said it's a reflection of policy considerations. And certainly so far as 2144 is concerned.
Yeah, they take the view, it's the second interpretation.
Now, the final point is to invite the court to reconsider the design corpus, which is the issue of infringement having regard to the three new designs which come in. And as I say, Milena Friend deals with that rather briefly, and I can see why he does that, because it depends, has he succeeded at all, and if so, to what extent, because someone's decided that, and these are, has he succeeded in ground one at all, in which case they don't come in, has he succeeded on ground two to a point, and if so, what's the point? So there's a multitude of various possibilities, but I will deal with the yellow designs briefly in any event, the three of them. Now, if one looks at Milena Friend's skeleton argument, what he sets out is core bundle paragraph 35A, page 27. Well, we'll see, it rather depends what view one is taking of grounds 1 and 2, but Milena Friend says 35A, he says it's not identical to any of the registered design. It has a very different surface decoration. the evidence doesn't show the nature of its stopper, and it has no light. So if it does come in to consideration for purpose of validity, why would this one cut down the scope of infringement? My friends just identified the differences, and these are all reasons why it wouldn't cut down the scope of infringement. Now, so far as B is concerned, the Clementine gin liqueur wine group, we would say that this, as I said earlier, is actually immaterially different as the one that the laws have invented. So whether Malone and Friends grounds 2 succeeds in respect of same designs plus immaterial variance or different overall impression, that one comes out of consideration anyway for purpose of infringement. So lawyers can disregard that one for purpose of infringement on 2 alternative grounds. And then the rhubarb gin liqueur, he says it's not identical to any of the registered designs. It has a decorative silhouette showing houses around the woodland scene, purple watch strap seal over the stopper, and differs from UK 82 and 84 in that it has no light. So he's still taking the point about no light, which is of course one of the points he's making. Now, again, he's caught both ways, isn't he? If he's trying to say that these are well, certainly as far as this one, he might say it's not immaterially different, but he wants to say it's the same overall impression. But if it's the same overall impression and it's second part of ground 2, this one comes out of consideration, so we can't rely on that to cut down the scope of infringement. And I'm not sure what Malone Friends' case is, but we say either of 2 things. If it is the same overall impression, then it gets disregarded. If it's not the same overall impression, then it just drops out of consideration entirely. It makes no difference. So at the end of the day, once we've worked through all these grounds 1 and 2, what difference has it actually made? And no submission, it doesn't. Even if you got all 3 of these bits of prior art back into the case, it's wrong in principle to consider any of them. But even if he did succeed, then on this ground, it wouldn't help him. No, the judge concluded, set out his consideration of infringement, it's judgment power 80. Now, paragraph 80, and we did look at this. Now, it's true that when considering, comparing the registered designs in such that Aldi bottles, they have identical shape, we would say. Now, Malone Friends says, oh well, what about all the prior art designs the same shape? This was Malone Friend, Mr. Elias drew attention to a few bottles. But these are all in the case already. Certainly the ones that one sees as far as the shape of bottle are concerned, they were considered by the judge. Top of page 24 of the judgment, page 120 of the bottle, and also the Sabre glass one, considered at the top of page 121. So bringing in the extra 3 designs has just brought a few more examples of bottles of this particular shape. And we would say, well, that makes no difference. And similarly, so far as the stoppers have concerned, bringing in a few more designs makes no difference to the overall conclusion. Point 3 was the winter scene consisting of the entirety. Now, the glitter globe doesn't have a winter scene at all, of course, and the rhubarb gin shows winter houses rather than winter trees. And if the Clementine gin globe comes into the case at all, of course we say it doesn't, then it does show a wintry forest scene, but if it would have to be disregarded for validity, which we say it would, why would it have any impact on infringement? So that's a way of saying that even if these designs come in, it doesn't make any difference to the judge's conclusion. And I was now going to go on to grounds 3 and 4. Unless my lords have any further questions on that. I'll therefore move on to, I'm going to deal with ground 4 anyway, which I was going to do in my pre-prepared notes, but also having heard what my lords observed this morning. If the judge is wrong in law, then it's not necessary to consider whether it's open to make the law, because he's just wrong in law anyway. Now, all Malone and Friends said about ground floor in law was a complaint about the conclusion, which was said to be illogical.
Say again?
The judge's conclusion was said to be illogical.
Yeah.
And the particular illogicality was illogical to assess the issue of infringement at a time when there could be no infringement. But there was no challenge to the reasoning the judge actually had, which was to go through what my Lord Justice Arnold, sorry, Mr. Justice Arnold then was, said in Dyson and Vax, and said, well, look, this all applies to priority. So we'll be urging my Lords to adopt the same reasoning as the judge did, so far as the point of principle is concerned. But the alleged illogicality, I'll deal with that first. My old friend did actually deal with this. He pointed out, and I've said as well this afternoon, that applications are made in accordance with Section 3 of the Act, and you apply and it gets examined, and there's a time lag and so forth. So the registrations aren't granted instantly, but only after examination. And you can only issue proceedings for infringement once the certificate of registration is granted. Now, the effect of that registration is backdated, that's true, to the date of application. But the short point is that on the filing date itself, and until the date of actual registration, there is still no right to sue for infringement. And that's section 7A, subsection 6 of the Act. I don't need to go there, but it's Joint Authorities, tab 18, page 557. Now, the reason I've made this point is because Malone and Friends' argument about the illogicality is to say it's illogical to assess infringement at a time when there could be no infringement. But of course, there couldn't actually be any infringement on the filing date anyway.
Well, that's what I suggested to him.
Yeah.
Because you're not assessing infringement, you're
Yeah.
assessing overall impression.
Correct. And that's the distinction. My Lord has it.
Unless you've done something that's forbidden by Section 7, there is no infringement.
Correct. Yes. But my Lord has the point. So then coming on to the more substantive point, was the judge right anyway? It's set out in the judgment at paragraphs 50 to 52. And he applies the logic which Justice Arnold, as my Lord then was, in Dyson. And he does apply it in a case where there is a priority claim, which there wasn't in Dyson itself. Now, I'm not going to read out all of 42 to 45 because my Lords have done that.
Well, he takes my Lord's reasoning in Dyson and he
Yeah.
bolts on Section 14.2.
Correct. Yes, which is the short point. I was going to be very brief then. I was just going to go through the 4 points in paragraph 44 and say what they all apply in case the correct date of priority date. Anyway, the first point considered in paragraph 44, that's Dyson answering a fairly weak linguistic point made on behalf of Vax. Second point is a more substantial one, and it goes back to the date at which design corpus is assessed. And this is the submission that the existing design corpus, and it is recital 13, must be the design corpus which existed at the date of registration. True, but if you're treating the application as having been made on an earlier date because priority, the same logic would apply to that too. It's the design corpus at that date that you're assessing for purpose of validity. So it's the same point, but for a different date. Thirdly, this Council of Dax submitted that otherwise the scope of protection could be eroded by subsequent designs which adopted the striking features of the British design one by one. Well, that's true too, because if there were a series of designs between the priority date and the filing date, which adopted the striking features of the registered design one by one, then if you're assessing design corpus as at the filing date, the scope of protection is going to be eroded, notwithstanding the claim to priority. It's quite a compressed point. Shall I make that one just a little bit? The point being made in number 3 is, well, so let's suppose we've got all these subsequent designs by infringers, or third parties at any rate, and they have the striking features of the registered design one by one. So if you have this, the clock starts at the application date, and then you have all these subsequent designs, and you're testing infringement some way down the line after all these designs which have taken all the clever features one by one. then the protection conferred by your registration has been eroded by all these subsequent, and that's contrary to principle. But exactly the same logic would apply if you had a priority date, and it's like 6 months earlier that the relevant date for assessing design corpus is. Suppose you had a series of third-party designs falling between the priority date and the filing date. Are they going to be held to erode the protection of registered design? Well, no, because then you're undermining the value of having a priority date in the first place. And then the fourth point, in comparison with Article 5.1, supported this conclusion, scope of monopoly could get broader over time. A prior art design, which is not close enough to invalidate registered design, Article 5.1, could later infringe it. And the same argument would apply in principle where you've got a priority date as well. So to return to what Lord Justice Newson just put to me a few moments ago, all his Honour Judge Haken did was he set all this out of Section 14.2 and says, well, the same thing applies when you've got it. And we respectfully agree. We say there was no error of law here. The judge was right. So then, was there any procedural unfairness about this? Well, simply no. It's not a case where the judge has made some finding of fact, which neither side asked him to make. It's not a case where he's found some extra item of prior art and based his judgment on it. The question is whether the judge was bound to do something which he considered to be wrong in law. And we respectfully say the answer to that question must be no. And nothing in the authorities, we would respectfully say, changes that conclusion. Now, I think the members of the court might be rather familiar with Satcham and other authorities, so rather than looking through them, I think it's probably worth going to the third, which is the Dink one. But the Satcham case, which is a decision of this court, what went wrong there was it was a factually complicated case. Judge accept was a completely new argument, which hadn't been raised or argued before it appeared in the judgment. And it was a case where virtually everything was disputed. So much of the evidence was disputed and unreliable. And this court, including I believe Lord Justice Newson, felt the judge's approach was unsatisfactory generally, so it went back for a further trial. And the beginning of this is Al-Madeni, which is a similar case where the judge came up with the third man theory, as it was called. Very unfair, my submission, to decide the case on that factual basis, even if it was canvassed during closing submissions. But in this case, we don't have the judge producing some new factual issue or deciding the case on some new factual basis. And I was going to look at Alien Dink briefly. It's Joint Authority tab 17, because this sets out the limits of the principle of frame relied. Now, what had happened in this case, I'll just show you passages from it just to set the background. If my Lord looks at the leading judgment of Lord Justice Burse, paragraph 2, permission to appeal was given by Lord Justice Newgee, who was the leading judge in Satcham. It's an oral hearing. He gave permission on a single ground, that was with considerable misgivings, and the judgment was 26th of February 2021. As it happens, that was shortly after the oral hearing of Satcham, but before the appeal in Satcham, before judgment was handed down. So these cases have been decided at roughly the same time. Now, 2 and 3 of Lord Justice Burse, he set out the facts were in the instant case of Alien Dink. If we go to pick up at paragraph 19, there's a beginning of a section on where I've already made brief submissions on the Al-Madeni case, and the Lord's turn over to the next page, paragraph 23, the Satcham case. I do wish to draw my Lord's attention to paragraph 25. Having set out all these statements of principle, Lord Justice Burse, with whom Lady Justice Whipple and Lord Justice Green agreed, he says this: I wish only to add the following. These problems are all concerned with the interests of justice and in particular the circumstances which cause prejudice to the losing party. The common sort of prejudice which is to be avoided is that a new point has arisen in such a way the losing party is not given a proper chance to call evidence or ask questions which could have addressed it. That is why the function performed by pleadings, list of issues and so on, which is to give notice and define the issues, is an important one. It is also why a judge can always permit a departure from a formally defined case which is just to do so. It is also why the judge's function is to try the issues that parties have raised before them, rather than to reach a conclusion on the basis of a theory which never formed part of either party's case. By placing the emphasis on prejudice, the point I'm making is that the modern approach to the definition of the issue requires judges to adopt a pragmatic approach in line with the overriding objective and not seek to be governed by unnecessary formality, provided always it is just not to do so. Now, having read out that passage, what was the appellant here not given a proper chance to call evidence? No. Was it not given a chance to ask questions which could have addressed it? No. Did they suffer any prejudice? No. It was a point of law which they now had their chance to say, make their submissions about it. And of course, this court permits pure points of law to be taken to an appeal, provided there's no unfairness in doing so. And I didn't hear Mr. Edinburgh really identify any unfairness in the judge's approach, which isn't addressed by the ability to have another go at persuading this court of the same point, which is now done. So,
Well, I mean, if we were to allow ground 3, inevitably we would have to go on to decide ground 4.
correct. That's why I dealt with ground 4 first. So ground 4 is both necessary and sufficient.
And we wouldn't reverse the judge on his holding without deciding for ourselves whether it was correct or not.
Well, precisely. My law's got the point. Because if my lawyers don't consider ground 4 succeeds, then where is the unfairness anyway? It just reached the right conclusion. Now, what are the consequences of allowing this in? Well, it's what I call the green design comes in. And I did show my lords this as I started this afternoon, but I'll just remind you what it looked like. It's sub-bundle sub-bundle tab 2, page 69. I did read this out to my lords. If this comes in, does this really make any difference at all? In my submission, it simply doesn't. Very different design. No wintry scenes, a riot of colour, and it's not surprising because it was a summer product. No light in this either. I mean, this is much further away than the red design, for instance, which I showed my lords earlier, which was at least a wintry product, and which the judge did consider. So the end point of this whole argument is to introduce one further item, which I say makes no difference in the facts anyway. So I'm very grateful to my lords. If there's any further questions on grounds 3 and 4, and I hope to have dealt with the subject matter of ground 5 as I went along.
Thank you very much.
In that case, I'll be followed by Dr. Selmy, who will address the court on ground 6 and 7 and the response.
Yes. Yes, Mr. Selmy.
My lords, I appreciate you've already heard 4 hours of submission, so I'll be as brief as possible. I will traverse some of the same territory that my learned friend Mr. Elias did, and that's because I wish to draw the court's attention to particular points and particular points of emphasis that he may not have made. So in terms of the structure of my submission, I intend to address the court on ground 6, 7, and then the respondent's notice, because as Mr. Campbell said, that is very much a subsidiary point, and for us, we don't rely on it in order to succeed. Ground 6, of course, is the contention is that the judge incorrectly interpreted the registered designs, and that's couched as in my learned friend's skeleton and submissions as a mixed error of fact and law. In my respectful submission, they haven't identified any error of law. It's a pure factual question, which means the Court of Appeal can only interfere with that if it's rationally unsupportable or if the conclusion is perverse on the basis of the material before the trial judge. If I could take your lordships to the judgment, which is a core bundle tab 11, page 101. paragraph 9, which I appreciate the court has already seen. But this is responding to the point that the judge was misled by, or erroneously placed some reliance on the description, or was otherwise influenced by the physical bottles themselves. And you can see at paragraph 9, the judge correctly directed himself that the scope of protection for registered design depends on what is shown in the image of the register. He then proceeded to correctly summarise the law from the Supreme Court in Magmatic. It's not necessary to take your lordships to that, but the key point from that decision is that the question must ultimately depend on the proper interpretation of the registration in issue, and in particular of the images included in that registration. And we see a similar point in the Procter & Gamble appeal, which again, it's not necessary to take your lordships to. And there, Lord Justice Jacob had made the point that the most important thing in a case about a registered design case is the registered design, the accused object, and the prior art. And he pithily said, and the most important thing about each of these is what they look like. Of course, parties and judges have to try to put into words why they say a design has individual character or is novel, but it takes longer to say than to see, and words themselves are often insufficiently precise on their own. So the important point, which of course the court will have, is that the interpretation of the registered design is ultimately a visual exercise, and it's a visual exercise that the court and the court alone undertakes. On that basis, the judge correctly directed himself at paragraph 13 when he said that the objective interpretation of the design is a matter for the court. And then picking up the judgment at paragraphs 15 and 16, the judge made some overturned remarks about the potential relevance of the description. So at paragraph 15, each of the registered designs contains a description. Both parties submitted that it was irrelevant. And then he considered why it may be relevant. Both my learned friend and I seem to be on the same page that these were overturned comments. By way of discussion only, the judge does not come back to them. And it's clear from reading the rest of the judgment that the judge only looked at the registrations and based himself only on what he could see in the images. So in terms of correctly directing himself in the law, there's no question that the judge was alive to the legal test and correctly directed himself in the legal test. So the question is there some basis on the facts to interfere? And as the court has been taken to, His Honour Judge Hakon assessed this case at paragraph 17. I was pressed by Mr. Selmy for M&S to look at the images before RDs and Suite. To my mind, or to my eye, the two registrations with images created against a dark background, UK 82 and UK 84 show the integrated light feature. The other two do not. So there's a reference to the registrations, there's a reference to my eye, and it's plain as day that the judge had construed the images by reference to the images, the registrations by reference to the images, as he was required to do. Against that background, Aldi contends that the judge wrongly interpreted the registered designs, and if I can marshal essentially 5 points from my learned friend. The first point is that the bottles and the liquid are dark. At this stage, if I could just ask your lordships to pick up the judgment at paragraph 2, which will make it slightly easier to follow my submissions on this point. And my Lord Justice Arnold had already made one of the points, which is that if the liquid was dark, then you would expect it not to include the top part of the bottle, whereas if the background was dark, then you would not expect that to continue in the way that it does in UK 82 and UK 84. And there are other points, such as a circular ring of light is visible around the neck of the bottle, which would not be visible in a dark bottle or liquid. If your lordships look at UK 82, especially the registration on the right, you can see the festive decoration at the back of the bottle appears distorted as one would expect when viewing an image on the other side of a round bottle with a liquid in it, and that's especially visible in the tilted view. Again, that would not be possible if the bottle and the liquid were dark. And it's also possible to perceive depth in the gold's leaf, which would not be possible if the bottle and the liquid were dark. So whilst we are not required to contend that the judge was right to succeed on this ground of appeal, we do contend that the judge was plainly right, and Aldi's factual appeal on this point goes nowhere. On the second point, which is that the judge gave no reasons for his conclusions, I do have a number of points to address you on the law relating to a lack of reasons, because my learned friend took you to the Comic Enterprise case. So I just wanted to provide a little bit of context to that. In our skeleton argument, we referred to the decision of Lord Justice Mayles in Symmetra, and maybe I can address you on this without taking your lordships to it. But in that case, the claimants claimed to have been victims of a Ponzi scheme. They invested huge sums of money in the defendant's trading platform, and there were issues of dishonest assistance, damages for deceit and conspiracy. So it was a very significant dispute between the parties. The trial itself lasted 13 days, and the judgment in that case only ran to 13 pages. So that's the context, a 13-day trial and a 13-page judgment. Against that background, and there is a section headed Inadequacy of Reasons, which is referred to in M&S's skeleton argument. And there, the court says, without attempting to be comprehensive or prescriptive, not least because it has been said many times that what is required will depend on the nature of the case, I would make 4 points which appear from the authorities and which are particularly relevant in this case. And essentially, those points are that what is required depends on the nature of the case, and no universal template is possible. In that case, the Court of Appeal reluctantly remitted the matter back after thinking, and this is a direct quote, long and hard about whether a retrial is necessary. So it was a 3-week case, and it was an extreme example of a case raising a large number of legal and factual issues, which the judge had purported to address in only a 13-page judgment, but had not. It's not difficult to see, having set out that background, that this case is completely different. As I mentioned at the outset, the interpretation of the register designs is a matter for the court. It's a visual exercise. So this is not a case where one would expect a judge to set out detailed reasons for his visual assessment. As Lord Justice Jacob had said in Procter & Gamble, it takes longer to say than to see. The words themselves are often insufficiently precise on their own. Therefore, whilst Aldi is in principle correct that a lack of reasons can be justification for reconsidering an issue, we say that that applies where the issue substantively require detailed reasons, and this is not such a case. Then Aldi had cited 2 authorities in a skeleton argument. Only one of them was referred to orally. And if I could take your lordships to English and Emery, which is in the Joint Authorities bundle at tab 1. In that case, 3 claimants had appeared to the Court of Appeal on the grounds that the judge had failed to give adequate reasons. And again, it's relied on by Aldi, essentially, for one-liner saying that a lack of reasons can be a reason for reconsidering, which is not in dispute, but it's important to think about the factual context of this case. Picking up the judgment at paragraph 16, in that case, 3 claimants had appealed to the Court of Appeal on the ground that the judge had failed to give adequate reasons. All 3 of the appeals were dismissed. Lord Phillips of Worthmer Travers considered the requirement to give reasons. And paragraph 16 on page 11 said, "We put the matter at its simplest by saying that justice will not be done if it's not apparent to the parties why one has won and the other has lost. As to the adequacy of reasons, as has been said many times, this depends on the nature of the case." So again, that just makes the same point that what is required depends on the nature of the case, and no universal template is possible.
But if you go back to paragraph 6 of the judgment, and the quotation from Crown against Knightsbridge Crown Court, between A and B, is Lord Justice Henry, then to the duty, it depends on the subject matter. Where there's a straightforward factual dispute about whose resolution depends simply on which witness is telling the truth, it's likely to be enough for a judge, having summarised the evidence, to indicate simply he believes X rather than Y.
I'm grateful for flagging that. I think that's precisely the point here. So Aldi can understand why the judge said that UK82 and UK84 showed an integrated light feature, whereas the other two registered designs didn't.
I think the real complaint was that there was a dispute about whether the bottle was coloured or the liquid was coloured as opposed to being a background, and the judge never dealt with that. That's the real complaint, I think, that Mr. Selmy makes. That Mr. Elias makes.
That's a number for the complaint, which I think I addressed up front.
Yeah.
There's no basis when one looks at the images for construing them in that way. It doesn't accord with
No,
the way-
I follow that, but I think they say, well, that's exactly what the judge should have done. If he was going to address the issue at all, he should have said, well, the colouring goes all the way up to the stopper, you can see the light, and so on and so on.
in my submission, the judge was not required to do that. He was not required to provide those sorts of reasons for a visual assessment, and he provided sufficient reasons for Aldi to understand the point, which is that two of the bottles were held to be against a dark background, hence the integrated light feature was visible, and the point didn't apply to the other two.
Can I ask a different question? Suppose you're right on this. Let us also suppose that you're right on your respondent's notice. Now, on those two hypotheses, 82 and 84 become completely redundant, don't they?
If we were right on the respondent's notice and we succeeded on 78 and 80, then that puts us in exactly the same position, because we say that all four of them.
Because as soon as you realise, or on your client's submission, as soon as one decides, I think that is the better way of putting it, as soon as one decides that what is shown in 82 and 84 is a bottle against a dark background, then it's the same as in 78 and 80, except that it's against a light background.
Absolutely, my lord. They're showing exactly the same thing.
So really, the critical point is actually the integrated light point, because the integrated light point is what bears upon 78 and 80.
The integrated light, we say we don't need to succeed on that, but obviously if we do succeed on it, then it bolsters the judge's conclusions, because it ends up being an additional common feature between.
I suppose, it's because he's found in your favour on 82 and 84, so far as the integrated light is concerned, and he's effectively accepted. He has accepted that it's a dark background. Yeah, okay, I understand.
I'm grateful, my lord. Then very briefly on Comic Enterprises, without taking you to the judgment, but my learned friend again referred to this in his skeleton and orally, cited Comic Enterprises. That was a trademark appeal in which Lord Justice Kitchen held that the judge's failure to give reasons amounted to material deficiencies. The lack of reasons in that case went to fundamental issues in trademark law, the assessment of similarity of goods and services, the assessment of the likelihood of confusion. So we say again, the error in that case has nothing to do with the sort of error that's been alleged in this case. And the third point is the alleged reliance on the products or description. Again, there's no basis for saying this. The judge assessed the images by reference to what was seen on the register. And on the description point, as I submitted earlier, they were obituary remarks. They formed no part of the judge's substantive assessment. The fourth point relates to the judge's comments in form N460. And if I could please take the court to this, which is in the core bundle at tab 12. And it's page 124. So in relation to ground 6, the judge said, ground 6 concerns an interpretation of the registrations on the facts. Again, emphasising this is an assessment on the facts, and then went on to say, the interpretation advanced by the claimant was preferred. On that finding, each of the designs is different, 78 and 80 light switched off, 82 and 84 light switched on, and 80 and 84 flakes in suspension. And so the judge was plainly just summarising what was then ground 6, namely the correct interpretation of the registrations. There's no basis for saying that supports any assertion that the judge had inappropriately relied on the description. That you can't read that into this. This was just shorthand. And again, I just repeat the point that the judge had just relied on the images as they appeared in the register. Aldi's fifth and final point was raised in their supplementary skeleton, and my learned friend mentioned it again today orally. And the point made there is that the images of the bottles that the judge held were taken against a dark background could in fact reflect a dark and translucent liquid that had the properties of something like tea. We submit that that argument's not remotely persuasive because the bottles and the liquids are plainly transparent and clear. A liquid such as tea would interfere, for example, with the perception of the gold, the depth and the gold leaf flakes, which are clearly visible in the registrations, especially in UK 8.4. So, my Lord, for those reasons, we contend that Aldi's appeal on ground 6 is bound to fail. And if I could also respectfully remind the court that my Lord Justice Arnold gave permission to appeal on ground 6 and 7, saying that he had some doubt as to whether the appeal on these grounds had success. I agree. It's not necessary to make the point to succeed on appeal, but we do say that it rather underlines it. On ground 7, Aldi contends that the judge undertook a flawed assessment of different overall impression. Again, we addressed that in a single paragraph in our skeleton. I'll also address you very briefly orally. The point being that the assessment of overall impression is a multifactorial assessment by the court. It's one that can only be interfered with if there is some error of principle. And my Lord Justice Arnold asked my learned friend whether the error of principle is that the judge did not conduct the analysis registration by registration. The answer to that should have been that was the alleged error of principle, and we say that that's absolutely not required. The judge undertook the analysis correctly. If I could take your lordships to the judgment, which is Core Tab 11, paragraph 77. So under the heading, the comparison of overall impressions in this case, paragraph 77, the task of the court is not to identify the closest prior art and then to decide whether the accused design is close to that prior art or closer to the registered design, particularly where the closest prior art is among here, as here among hundreds of members of the design corpus. Its influence on the assessment may be limited. Relevant to this, Lord Justice Jacob also observed in Procter & Gamble that the design corpus does not have a bearing on the assessment of infringement because of any statutory provision or other rule of law. It arises from the way that human observation works. There is a continuous spectrum of possibilities.
We have read this, of course, Mr. Sutherland.
Yes, my lord. The point is paragraph 80, which you have also been taken to.
Yes.
So the judge had identified 5 similarities: the identical shapes of the 2 bottles, and what appeared to be the identical shape of the 2 stoppers, a winter scene over the entirety of the straight portions. In the case of UK 1884, a snow effect, and in the case of the other 2, an integrated light. And if I could just ask your lordships to read the differences which have been identified at paragraph 82. Aldi rely heavily on the differences, but it's important, as the judge directed himself at paragraph 83, going back to the statutory test, is whether the registered designs in the Aldi bottles produce a different overall impression. In my judgment, they do not because of the features they have in common. The differences to which Aldi points out are there, but their differences of relatively minor detail. So against that background, Aldi's trying to re-argue the case in the hope of obtaining a different outcome. The first point, there are essentially 4 points on ground 7. The first point is that the judge failed to give any sufficient weight to the absence of the integrated light in UK 78 and UK 80, or the absence of a snow effect in 78 and 82. And whilst the judge correctly held that those were there in relation to some of the designs and that they were important common features, the point is that they make M&S's case stronger and the absence of them does not make what would otherwise be infringing not infringing. On the second point, which is that UK 78 has no light and no snow, so essentially it has no light, no snow, so it must be so weak as not to be infringed. And again, we say that that fails to take account of the fact that the bottle shapes are the same, the stop is the same, the winter scenes at that level of generality were identical. And as the judge directed himself stepping back, the designs gave the same overall impression. The third point is said to overlap ground 6 and 7 with ground 6, which is that UK 82 and UK 84 contained a dark bottle tint or liquid. I've already submitted why that's hopeless, and it doesn't come back to assist Aldi here either. And the final point relates to the white light in UK 82 and UK 84. Aldi contends that the judge failed to take account of this, and this is an important difference. But of course, the judge is not required to set out every similarity and difference, and that's not, in fact, the correct way to undertake the analysis. The analysis is the overall impression. So he set out some material similarities and differences and gave the ultimate conclusion at paragraph 83. Again, here we say that the judge's conclusion was plainly right. We don't need to go that far. He was certainly entitled to the conclusion, and Aldi has not identified any error of principle. Then, my lords, briefly on the respondent's notice. The point is, we contend that the judge correctly set out the law and the interpretation of the registered designs as submitted earlier. But if the appellant's ground 6 has any traction, because this court contends that the factual assessment was rationally unsupportable, which we say cannot be the case, then it's open to this court to reinterpret the registered designs, and we would then invite the court to hold that all 4 of the registrations show an integrated light feature. And if I could just take your lordships to the respondent's notice skeleton, which is in the core bundle at tab 7, and it's the annex right at the end, it's page 62. In a nutshell, M&S's reasons for saying that all 4 registered designs show the integrated light feature relate to the way that the light interacts with the bottle and the illumination that it produces. You can also see the punt or the dimple, which is equally visible in all 4 of the registered designs. If you compare UK 78 and UK 82, you can see the punt or dimple in the base of both registered designs. It appears illuminated in both. It produces the same light pattern in both. You can see a circular ring of light around the neck of the bottle, which could only be produced if the bottle was being internally illuminated. A comparison of UK 80 and 84 shows the same punt or dimple in the base of both. Again, you can see the same circular ring of light, which is consistent with internal illumination in both. And finally, UK 80 and UK 84, the interaction of the light with the gold leaf flakes is the same in both registered designs, and they appear illuminated internally, which again is consistent with illumination at the base. And I should be clear that we're not asking the court to interpret or assess the registered designs by reference to each other. Rather, we're saying that it provides a basis, and the comparisons provide a basis for saying that the judge did not correctly interpret them if the court is minded to reopen ground 6.
Yes.
My lords, I didn't have any further submissions unless there are any questions.
Are you able to enlighten the court as to why the state of the register has changed?
The short answer
I
is
speculated earlier, but that is pure speculation.
no, my lord. The short answer is no. You're exactly right in that we found out, having drafted the initial skeletons when we were putting in the supplementary skeleton, that it had changed. I suspect you're right because the judgment does refer to Rule 5.5, which says that the register needs to show an indication of product, and says that there was no indication of product. So perhaps that was picked up on by the UK IPO and they amended for the reasons that your lordship gave.
Right. Well, I think it's only fair that we should give the IPO a chance to explain themselves. So could I ask you to just drop a short letter to them saying that we're interested in this and would be grateful for a short explanation as to why the register's changed.
Of course we would.
If possible, it should be a letter jointly from both parties.
Yes. I'm grateful.
Yes, Mr. Eden, do you wish to reply?
My lord, if I may, might I just pick up on the point that my lord Justice Arnold has just made? We didn't know about the change either. We were surprised that the IPO had not notified the parties. We didn't there we go. And my lord also might know that I know quite a lot of what's about to happen at the IPO, and I did not know anything about that. So therefore, I was taken doubly by surprise, if you see what I mean. I have a few short points in reply. The first one is with respect to the Pepsi point about whether or not it's appropriate for this court to look at products that are purportedly made to the registered design. And there is, of course, the starting point in the judgment, paragraph 14, where the judge quotes Lord Justice Jacob in the iPad case, and what the Court of Appeal then considered to be the right comparison. But also, my Lord Justice Arnold has referred to Russell Clark and paragraph 2071, and the relevant footnotes that follow that all indicate that there is potential minefield there with respect to the fact that the product that is purportedly made to the registered design actually contains material differences. So you're alive to all of those, but I just need to highlight that. Then that brings me to actually this IPO point. There is a problem here in that if you look at, and I don't need to take you to this, but what was on the register was that there was a title called description, and under that, light up gin bottles, and that's now been replaced with indication. But under that, in the IPO register, there was a heading called classification, and that referred to the Locarno classification. But if you look at...
That's not changed.
Yes, but if you look at the registered community designs printout that we handed up to...
Classification's different.
Yes, but...
But it's all...
Yes, but if you consider the EU IPO printout, what it says is it puts the Locarno classifications under the heading of indication of the product. And that's the short point I'm making there, is that there's a mismatch between the EU IPO and the way it presents the various pieces of data and identifies, in essence, their functionality, and the way in which it was done in the UK IPO, and still with the way in which it is now done in the UK IPO. And so therefore, it would be probably helpful if the UK IPO, in the letter to which they're going to send to this court, maybe gave some thought to that.
I'm sure it's my fault, but I'm not quite understanding the point you're making. It is clear from the documentation that the classification applied was different in the two offices. So
Yes.
EU IPO says that the product is classified in Locarno Class 9, subclass 01, also Locarno Class 32.
My lord, yes.
Whereas UK IPO have classified it in Locarno Class 11, subclass 02.
Yes.
Now, one can debate the merits of those classification decisions, but A, that's not a matter for us. B, we are still left with the fact that they're different.
No, sorry, my lord, I wasn't trying to drill down and criticise the different ways in which the different UK IPOs classify the product. The point being is that in the UK IPO, they've put the Locarno information under a heading called classification. But in the EU IPO, they've put that information under a heading which is indication of the goods. So,
Does it
But
make
I
any
think-
difference to anything we have to decide?
well, I don't think it does, but
Well,
I think
let's
you need
move
to be alive to it, because the UK IPO.
Well, at the moment, my belief, and I may be wrong about this, but I'll say what my belief is. My belief is that the two registers are structured in a different way.
Yes.
And what in the EU register is presented in one place is separated out into two places in the UK register.
And it would,
I appreciate I may be wrong about that. That's
but it would be helpful if the UK IPO, in response to your request for a letter.
well, but since we're asking them to explain themselves, it would be nice to have an explanation of the way the register's presented as well. I agree.
Yes.
Thank you.
My lord, then the next point is my lord Justice Arnold raised, in essence, a rhetorical question: was there anywhere within the legislation, and you expanded the definition of legislation, that set out was the design corpus defined for the purposes of infringement? And the answer, as far as I can ascertain, is no. And the reason I would say it is no is because of the central importance of the application date. Basically, everything is ascertained at the application date in my submission. So that would be infringement and validity. But, of course, there are two big exceptions to the validity point: priority date and grace periods. And even though there are fundamental differences between them, they both operate as an exception to the central importance, the touchstone importance of the application date for determining everything. And the way in which the priority date and the grace period operate as exceptions, they operate in slightly different ways to restrict the relevant corpus that you take into account. And that is expressly on the wording of the UK Registered Designs Act 1949 for the purposes of validity. And so it partly answers my Lord Justice Arnold's point that it doesn't appertain to, I would say, infringement. Now, the point was put against me that this relies upon a close textual analysis of the Registered Designs Act 1949. The answer to that is yes. But it's
Yes, well, your position is quite simple. You say that's what it means.
that's what it, that's,
Wh-
that's what it
whether-
says.
Whether
Yeah.
whether that should be the law is different, but that's what the law is.
Thankfully, that's not a question that I need to answer, but I need to say it is a difference, and it expressly says that, and
Yeah.
that's as far as I go.
Very
Um,
straightforward point. if I may
Yes,
say.
I've long-windedly explained it, but yes. The next point is that yes, there's a different purpose with respect to priority date and grace period, but the express purposes of each of those can be fulfilled quite rapidly, in particular with respect to grace period, which is the particular thing that's before this court. And there's no need, once you fulfill the express purpose of the grace period, to hang around.
Yeah.
And if you do hang around, you've already got the express purpose of the grace period tucked underneath your belt. And so why should have some other further advantage? Then there's a point about these other designs, which are coloured in yellow, orange, depending how the printers actually worked, on that table, which is recently produced. And the real point here is, what we say is the completely logical position is that everything should be excluded for the purposes of infringement. But if you are going to include something, then obviously there's this cascade. But even if you were to include things that do not have the same overall impression, and so therefore may be caught depending on where you alight on ground 2, those things would still affect the perception of the informed user. So it might not be something that has the same overall impression with respect to the registered design and therefore be excluded how you alight on ground 2 because it's disclosures that fall within the grace period and therefore the applicant can discount them for the purposes of validity. But if they have some of the features, then that will bear upon the perception of the informed user. And if other things which have been disclosed by the designer have other features, then that will also have an effect. And their cumulative effect will be, we say, material and therefore change the assessment under ground 5. And the last point relates to this point that when you have an application for a registered right and it's then effectively backdated to the application date, then there is a period between the application date and the right being confirmed. But the point is that any third party in that intervening time is on notice that an application has been made. And that's different from the position of a third party doing something before the application has been made. Because at that stage, they can't be on notice that an application has been made.
Yeah.
I think that slightly answers my Lord Justice Lewison's point, but I'm not sure it completely deals with that. My Lords, those were my quick points. My engineer is going to... my Janie is
Yes,
going to...
that's really nice.
I have just 3 points, my lords. The first relates to ground 6. And my learned friend made a number of submissions about what he says must be deduced from certain rings of light on the registered designs, or the fact that he says if the liquid were tea, it would have an effect on the depth or the perception of depth in the bottle. I would just say that we don't accept those points as a matter of that necessarily follows, and there's certainly no evidence about any of that. But the simpler answer to that, which is mentioned in our skeleton, but I think I didn't mention it orally earlier, is that, of course, these are simply photographs, and the Marks and Spencer could have lit the bottles however they saw fit. So it's quite possible that any effect which would be produced by an integrated light in the base of the bottle could just as easily have been produced if a bottle without such a light was illuminated from below. The second point relates to the Symmetra case, which my learned friend Mr. Selmy took you to. He took you to paragraph 46. And the fourth point in that paragraph, I don't dissent from that at all, the fourth point in that paragraph just makes the point that fairness requires that a judge should deal with apparently compelling evidence where it exists, which is contrary to the conclusions which he proposes to reach, and explain why he does not accept it. Now, by analogy, because of course I'm not saying there is evidence on this, but by analogy, I would say one looks at UK 82 and 84, and the thing that really strikes you, first of all, is that it's a dark design. And of course, the judge is entitled, there may be reasons why a judge would reach a conclusion that that darkness forms no part of the design. But in my submission, that is a really significant feature that calls out for an explanation. And my third point relates to the respondent's notice. It was made abundantly clear by Mr. Campbell and Mr. Selmy in argument just now that this is really only relied upon as a sort of squeeze, and there is no identified material error which would permit this court to reopen that issue. The position in respect of the dark-coloured registrations, I say, is very different. I took your lordship to the fact that there is, in my submission, a real material error which does allow your lordships to look into it. So there's no parity between those two issues. That's all I have, unless there's anything else.
Thank you very much. Well, thank you all for your interesting arguments. It will not surprise you to learn that we will reserve our judgments. You will get a draft in the usual way. It comes with a fierce embargo, which means what it says. So it is restricted to the distribution list which has already been supplied to the court. Receipt of the draft will be your opportunity to correct our English, but not our reasoning, and nor to introduce any new arguments. We would hope that in the light of the draft you will be able to agree an order disposing of the appeal, but if you can't agree a form of order, please make short submissions in writing. We will make the form of order that we consider to be appropriate. The hand down eventually will be remote, so it will be distributed electronically, released to the National Archives, and there will be no need for any further attendance. Thank you very much.
Could I just hand back one of the samples, because I think it's sufficient to have one of each sides. So
Should be
hopefully
easier to get
returning it
out.
later. But if I may, I'm going to hang on to the other two for the moment.
Just for my lord's information, that might be the one and only.
I beg your pardon?
The one my lord has might be the one and only that we still have.
I will bear that in mind.
Yes, thank you.
Thank you.
Guys,